currently styled BGT versus Department of Children and Families. The subject of today's proceeding is an order to show cause directed to Attorney Leonid Kremenchuker. Counsel, please make your appearance for the record.
Yes, Leonid Kremenchuker, attorney for the appellant.
Thank you. We will conduct today's hearing with at the beginning with any specific questions that the panel has for you, counsel. And then before we conclude, we will give you an opportunity to add anything or say anything that you would like to say. I will begin, and we are in receipt of your written response to our order to show cause. Can you just tell me if has anything changed in the trial court since you filed that response? You indicated several things that you had filed there.
I filed proposed order appointing appellate counsel in this case, order releasing digital transcripts of court proceedings, and proposed order to obtain and pay for transcripts. And I received from judicial assistant of the judge information that they intend to sign it today, but the judge didn't sign them yet. And previously, I filed several motions I was thinking would resolve the case, but apparently they were not. I know that the appellant was adjudicated dependent for the purpose of appeals, but the appellate attorney wasn't appointed, and I really don't deal with those cases much. I deal with the lower court in the dependency proceedings. This one is, I believe it doesn't even have the correct style of the case. It's not supposed to, appellee should not be Department of Children and Families. It was a DR case. And
well, counsel, that's one of the matters that concerns us. There was a motion filed by DCF to correct the case style, indicating that this is not a normal TPR proceeding from dependency, but rather from a step parent adoption. But let me back up a little bit. You indicated in your response in paragraph 5 that at the present you were not aware of any pending motion referenced in our October 7th order. And that's the motion that we're talking about to correct the case style. Did you not receive the court's orders, or do you not have access to our docket to be able to review what has occurred in the case prior to filing your response?
I think I found all of that in the lower case, on the lower case docket. I just don't even know how to do that. Usually I used to, and I never had DR case going through the same process. With dependency cases, and I used to work for regional counsel, as soon as I file notice of appeal, the appeal attorney actually takes over. And here I was thinking that the appeal attorney would take over the case and do the correct things here. And I didn't know what to do about that. Also, I'm located in a mandatory evacuation zone for Hurricane Milton, and at around the 7th of September, I'm sorry, I looked at when the first order came out, I didn't even see it because I was evacuating, and that was following with my vacation out of continent. And
do you not have email when you travel, counsel? Do you not
I do, and I should have. I at that time I thought this case was already transferred to appeal attorney.
Mr. Kremenchuker, are there, before we go on, are there any other cases that you have pending in our court where you have filed a notice of appeal in the lower court, and it may be proceeding in our court either without your knowledge or without appellate counsel?
We were looking at another case that I filed a notice of appeal, and we're following and making sure that all the orders are filed with the judges, and we'll keep an eye on all those cases.
Do you happen to have any case numbers that you have filed in this court?
I can find. Yes, there is another case. I think it would be easier if I will ask my assistant, because I don't keep.
Well, fair. We can come back to that. I'll just make a note to check with you again before the end here. I guess the overarching question, counsel, is that it's my understanding that if you file a notice of appeal, which triggers activity in our court, the opening of a case and an acknowledgement letter from our clerk indicating that the case has been opened, that would have been directed to you. It seems like you still have an obligation as counsel to either move to withdraw or ensure that the case is being handled. And in this case, we issued several orders. I understand from your response and your comments today that perhaps you weren't looking for those or had not been did not put yourself in a position to receive those. But if you didn't expect to proceed as appellate counsel, why didn't you simply move to withdraw when the case was opened?
I filed motion to appoint appellate attorney on 16th of September in this case here.
In the lower court?
In the lower court.
And maybe we don't automatically receive everything that's filed in the lower court once the case is open. Let me ask the other judges on the panel if you have any specific questions for Attorney Kremenchucker.
I mean, counsel, I can understand if you don't normally handle appeals. The problem is here you filed one. You said you thought appellate attorney had taken over or would take over. What made you think that?
There is a registry for attorneys that handle appeals. I was on the registry for attorneys that handle dependency cases. This one is a DR case, and I'm not even sure why I was appointed, but we handled it the best we could. And
Okay,
I thought that the issues for appeal were there.
But you did know that no other appellate attorney was in fact appointed, right?
At the time I had to evacuate, I knew that my client was adjudicated the indigent for purposes of appeal. And at that time, I didn't see actual appointment of appellate attorney, but at that I assumed that it would be appointed. The attorney would be appointed.
I understand you say you assumed that it would happen, but you'd received no notice that it actually happened, correct?
Correct.
Okay.
Yeah.
So throughout the case, you've been the only attorney of record for your client, and you knew that, right?
Yes.
Okay.
Yeah.
And I'm counting 5 court orders directed to you that you didn't respond to. So I see a September 18th order requiring you to give us a status report specifically about the appellant's representation in the appeal. And any order appointing counsel. So we asked you, what's the status? We didn't ask you, we directed you to give us information as to the status of the appointment of any counsel, and you just wholly failed to respond. There's an order to show cause for lack of jurisdiction because your notice of appeal didn't attach the order necessary to show we had jurisdiction. No response whatsoever.
I believe, I apologize here. I believe we did file that with final judgment.
So, no, you did eventually file an amended notice of appeal. So we issued an order to show cause on September 18th. You did not respond to that. October 1st, we issued another order for an amended notice of appeal. You did file the amended notice of appeal 3 days later on the 4th, which tells me you're getting our orders, right? Because clearly you received the order to file an amended notice of appeal, and it tells me you know which court you're filing with. So the amended notice of appeal did come in, but there was no response to either of the September 18th orders, and there has not been response to further orders. There was the motion to correct case style. We actually sent a separate order ordering you to respond to DCF's motion. No response. There was an order on October 17th in respect to the fact that the record was vastly overdue, ordering you to get the record prepared and served within 5 days, no response. And then another order on October 21st, ordering you to respond to our October 7th order. So I can understand if you don't normally handle appeals and if you don't feel equipped to handle an appeal. And that's a good reason for you to have been searching for other counsel. But the problem is you knew that there was no other counsel. You knew that you were the only attorney of record. and you got 5 different court orders telling you to take action. And it's not like you responded and said, hey, for some reason I can't take that action, or here's my explanation, or please give me more time. I'm trying to get an appellate attorney involved. You just wholly failed to respond to any of them. And then on top of that, the things you did file were very sloppy. I mean, every single document you have filed in the case lists the wrong court of appeal. So I guess that's what I'd like you to respond to. I understand your unfamiliarity with appeals, and if you were hoping somebody else would take over, and if you may ever make that happen, but why the complete, when you have 5 court orders directed to you saying, hey, do this, or just tell us what's going on with appellate counsel in one instance? Are you going to have other appellate counsel? The complete failure to respond to multiple court orders. Why was that?
It is oversight on my part, and I should be looking through those emails. Emails are the only way I see those, and I rely on my assistants, and the buck stop with me. I understand. The reason I probably mentioned the 2nd District Court of Appeals as a 6th district, that's because the previous appeal was filed in the 2nd district. It's been a while. I do those cases. I do notices of appeal maybe once every 2 years or so, maybe once a year. I don't know. It doesn't happen that often. I'm not on the registry to handle those cases. I wasn't supposed to handle that case. I was just relying on the judge to appoint an appellate attorney.
So, counsel, I just to follow up with Judge Mize's questions, and I don't mean to beat the dead horse, so to speak, but I mean, if you were on vacation or you were out for Hurricane Milton, and you're unfortunately you don't give us exact time frames when you're out for Hurricane Milton. You just said you had to evacuate, and then all of a sudden you're on this vacation. We're not really given time frames, and we're also not told whether you brought your cell phone with you, a laptop, whether you could have sat at a Starbucks and opened up your email account. But I mean, if you would have gotten an offer on a case to settle a case for $1 million for a personal injury case, I would assume you would have probably spotted that email and responded to it. Am I wrong?
I wish I did. My office was closed for a week. Usually we deal with local cases, and I aspire to respond to every email, and especially order from a court of appeal. But
Counsel,
it is an oversight, and
you're breaking up on sound. Can everybody hear him, or is it just me?
I can hear him.
Yeah, I can hear.
Counsel, do you think it's acceptable as an attorney to shut yourself off from communication and not be aware if you get some emergency court order? I mean, even if it's trial work, it's one thing if you have something going on and you find someone to cover for you. Hey, please monitor for this. I'm going to be unavailable for 2 weeks. Things come up, and sometimes people aren't available. And as an attorney, the responsible thing to do is make arrangements for somebody to handle anything time sensitive, or to be aware of any emergencies or deadlines coming in. Do you think it's acceptable to go on vacation and not have mechanisms in place to make sure somebody is monitoring your email? I mean, what if one of your clients had an emergency hearing come up in a trial case? How would you know those if you're just leaving for weeks at a time without any monitoring in place for orders that come in?
Yes, Your Honor, I agree, and there is an attorney to whom my assistant always refers the questions, but at that time we just didn't even expect appellate cases to even be at issue. I assumed that an appellate attorney will handle this particular case, and my assistants were at the office, and I wish we caught up with that, and I wish we responded, but I apologize we didn't.
So, counsel, I apologize. My sound, for some reason, my speaker broke out, and I couldn't hear anybody for just a moment there. So I'm just going to jump back into where I was. So going back to that $1 million offer. So if you would have been out, let's go from September 18th until October 28th. If you would have received that $1 million settlement offer on your case, on some personal injury case, you're saying that you wouldn't have spotted that email? That it would have just gone into the ether and you wouldn't have noticed it during that month and a half?
You wanna, the orders from a court of appeals have the same priority as $1 million offer to me, and I wish I did spot those, but I didn't, and I apologize.
So are you telling me then for 6 weeks, it wasn't just our case? You weren't looking at the emails of any of your cases? Like all of your cases were just off the radar for a period of 6 weeks or so?
My assistant didn't expect any court of appeal cases to be at issue during this
Well,
time.
that's not particularly what I'm asking. I'm asking about all of your cases. Are you saying that for 6 weeks, you just stopped checking any emails related to any of your cases?
I was, yes, Your Honor, I was checking the emails, and I apologize we missed those.
Okay,
I was
and so then
checking.
that brings me to my follow-up question, which is you were checking your emails. These appellate court notices with these orders would have gone to your email,
That's correct.
right? Okay, so you would have seen them.
Yes, Your Honor.
Okay, and if you would have seen them, then you did see them, and you chose to not respond to these because you assumed that somebody else would step in to handle them. Am I missing something?
I was expecting someone to be appointed in this case.
Okay, all right. I appreciate your honesty with the court. I just I wanted to make sure I got the full picture there. Okay, anybody else?
If there are no further questions from the panel, Mr. Kremenchuker, is there anything you would like to add or say? Understanding our fundamental question here is, whether we should or should not impose sanctions for your not fulfilling the appellant's responsibility to ensure the record is provided and not complying with our various orders. Also keeping in mind that one of the sanctions proposed in our prior orders was dismissing this appeal, which of course would harm your client far more than it would harm you. So can you just please address or add anything else you'd like us to consider in answering that question, whether or not to impose sanctions?
Oh, in any case, my client is not at all at fault in this case. I have been communicating with him and with his family, and I would ask the court to proceed with this appeal. I will look for orders from Court of Appeal extra vigilantly in the future. I don't get many of those, and I should have noticed the ones. And I did respond to some things to correct the judgment and to add additional to add the final judgment to attach it to the amended notice of appeal. But I'm not as skilled in appellate work, and I never claimed to be that skilled. I'm really hoping that another attorney will take over this case. And I expect it to be done within a day or two. The judge has the order. I drafted the order. I thought it would be just issued by the court. The way it's done in dependency cases, the court just issues the order without really us requesting for it. But I drafted the order, and I'm hoping it will be signed today.
Thank you, Attorney Kremenchuker. Any further questions from the panel? All right, thank you. We will take the matter under advisement, and we are adjourned.
Thank you. Yeah.